Hello. So I'm carrying on with tort and looking at trespass, but this can lead into assault. So I talked about that Collins and Wilkins case that Lord Justice Gough sat on way back in the 80s, if I remember. Anyway, the judge said that assault is an act which causes another person to apprehend the infliction of immediate unlawful force on his person. Close quotation. His person meaning his body. Notice the force doesn't actually have to be applied. Raising the fist, even if you don't actually punch the person, that is assault. If you punch them, it's still assault. But either way, so making the person fear the force, or in fact delivering the force, it makes no difference. So here we intend that a voluntary act be committed, or be reckless to this act, so that the claimant can reasonably believe that there's going to be the immediate infliction of unlawful force, not infliction at a much later date of that unlawful force. Notice it's got to be unlawful. If the doctor gives you an injection with your permission, that's lawful. If an emergency situation, doctors stick needles into you or something like that, and you're saying, no, don't do it. I mean, you're dying. They just brought you in after a car crash. You're losing loads of blood or something. Well, that is still lawful, the doctors to do it, even without consent. Stevens and Myers, 1840. The claimant was the chairman of a parish council, and it was voted by a majority to expel someone from this meeting. So this person refused to go and became loud and aggressive and moved towards the plaintiff, saying he would pull him out of his chair rather than be kicked out of the meeting. So the defendant, who's the chairman of the meeting, the defendant then grabbed the plaintiff, who was the chairman of the meeting, but was prevented by someone else, stepped in. A church warden prevented him from doing so at this parochial meeting. The issue that the judge had to rule on was whether the defendant's threat was enough to make the plaintiff believe that he was going to suffer immediate physical harm. That's battery. So the defendant was liable in assault because Chief Justice Lord Tyndall said, though he was not near enough at the time to have struck him, yet he was advancing with intent. I think this amounts to assault in law, close quotation. So the bad guy, the rude, aggressive man who's been told to leave the meeting, is coming to the chairman, I'm going to pull you out of your chair. He actually doesn't even get within arm's length of the person before he's overpowered by others. But nevertheless, the chairman was left in apprehension of the application of unlawful force. So it was assault. So, so it's got to be immediate and direct infliction of illegal force. This is an issue that the courts had to muse about when it came to Thomas against National Unions of Mine Workers, 1986. This is going back to the miners' strike of 1984. So there were miners who were picketing a colliery, as in standing outside it saying, with a big placard saying, on strike, industrial action, do not cross this picket line, don't go in there, you're a scab if you do so, because you're undermining the strike. So they'd be chanting, they'd be singing, and they would really detest you if you did go and work despite there being a strike. Not everyone was in the National Union of Mine Workers who was a miner. Some people at NUM disagreed with it. Anyway, so they did sort of hand signals to those who were going into work to suggest that they were going to suffer for it. I don't know, I guess one's like, whatever it is, and that was very menacing. But these workers were coming in in buses, so it was found there was no liability assault because the buses were behind police barricades, and the men in the buses couldn't believe there's going to be the immediate application of assault. It would have to be hours or days later they'd be assaulted. So what can words count as an assault? This is an issue that courts have tussled with down the centuries. In R against Mead and Belt in 1832, it was found that no words or singing are equivalent to assault, close quotation, unless they're accompanied by some threatening action, like I did, showing the fist, showing going to cut your throat, or a gun, or something like that. So it could be the words plus the hand gestures. In R and Wilson, 1955, this was overturned. It said, get out knives can be assault. The words get out knives, even if no knives were not actually got out. It said that words can negate a potential assault. So in Tuberville against Savage in 1669, here the defendant put his hand on his sword, and he said, if it were not assize time, I would not take such language from you. But it was found that by his words, the defendant had shown that he wasn't going to assault the person. It was not battery, not going to assault him any time soon, because it was assize time, as in when the courts met every so often to decide issues in that local area. So it's been said that a reasonable person in the position of the plaintiff, seeing that sword, might have been frightened. But anyway, it was found that the defendant was not in the wrong here. There was another case of R against Ireland as a criminal case, not a tort case, 1998. 3 women claimed they suffered psychiatric injury because they got these silent phone calls from the defendant. He'd phone them up in the middle of the night, say nothing. That was it. That's all they'd hear, the breathing down the line. The Court of Appeal said that the law had to develop to take account of situations which hadn't been in the contemplation of authorities centuries ago, when telephones had not yet been invented. So this is a person of evil disposition, the court found, could cause someone to be scared, and in some situations even silence can be an assault. So the Protection of Harassment Act 1997 deals with this sort of scenario. There's also false imprisonment. Okay, that is the complete, deliberate and unlawful restriction on the freedom of someone's movement. But it doesn't require actual incarceration or indeed using force. So the restriction was not total in Byrd against Jones in 1845. Here the defendants were trying to allow some seating for people to watch a boat race on the Thames, and they cordoned off an area beside Hammersmith Bridge. That bridge has been closed to road traffic for a couple of years now. So the plaintiff said he had the right to use part of the footpath that had been cordoned off, but he was unable to do so because the defendant told him he has to go back that way you can't come through here. So he refused, but he had an alternative option. He could go around. There was no false imprisonment. So there's got to be no reasonable egress from that place. If someone locks you in the room, there is a way out. You can climb through that window. But that window is high up. That's a bit dangerous. That's not reasonable egress from the room. Anyway, so there was no false imprisonment in that case, Byrd and Jones, because imprisonment is a total restraint of the liberty of the person and not a partial obstruction of his will, whatever inconvenience it may cause him. That was the court ruled. A bit like when they block off a lane of the motorway. I'm in prison because I can't go here. There's the other lane that's open. Robinson against Balmain Ferry Company Limited, 1910. Here the plaintiff was a lawyer who missed a boat and had to wait 20 minutes for the next boat across the river. But there was a turnstile by the exit, and he refused to pay the penny to get out of the turnstile. The defendant's employer said, we're not going to let you through. You either pay the penny or you're not getting out. So, anyway, there was no false imprisonment because he could have paid the penny, right? That's a very easy way to get out. That's a reasonable way to get out. Moreover, the plaintiff knew this before he went in through that dock. A reasonable condition must mean the restraint was by no means total. Remember, this is going to be deliberate. So the issue here is when there's formal imprisonment. In R against Governor of Brockhill Prison, Ex parte Evans number 2, 2001, a prisoner had been kept in prison for 59 days beyond the day she should have been set free. So she paid £5,000 for false imprisonment, even though the prison governor was not culpable for the date of release being miscalculated, because it had been according to the law that had existed at the time of the calculation, but the law had subsequently been amended. But in dismissing the appeal, the judges in the House of Lords said that the prison governor's belief that the prisoner was lawfully incarcerated was not enough of a justification for keeping someone in prison illegally. So he didn't need to intend to keep her there illegally. Seems that the law was a bit too generous to that woman. So the issue about whether the defendant's omission can be false imprisonment is one which the courts grappled with in Iqbal against Prison Officers Association 2009. In this case, the prisoners claimed they'd been false imprisoned because they had to spend an additional 6 hours a day locked in their cell because there was a no-notice strike by some prison officers. There weren't enough prison officers to supervise them going from the cells to the exercise yard and being there. The Court of Appeal said that the usual principle is that a defendant is not held to be liable and tort as a result of inaction unless he had a specific duty to carry out that action. Inaction is not doing something, as in not letting them out of their cells to go for exercise. So the failure of the prison officers to execute their contractual duties involved no positive action on their part. It's similar to Heard against Weardale Steel in 1910. So remember that the defendant, sorry, not defendant, forgive me, the claimant doesn't have to be aware that he or she is in fact detained. And this is found in Mearing against Graham White Aviation Company Limited, 1919, which overturned a decision by a court in Herring and Boyle. In Herring and Boyle. So here the plaintiff was suspected of stealing from his employers, and he's brought to the company's office to be interrogated. He didn't realise there's a police officer outside the office, and if the plaintiff had attempted to leave, he would have been stopped from doing so. The Court of Appeal held there was no need for the plaintiff to know that he was being constrained, but the extent of the knowledge of detention is pertinent when deciding what damages to be awarded. So Murray against Ministry of Defence 1988, the House of Lords ruled, the law attaches supreme importance to the liberty of the individual, and if he suffers a wrongful interference with that liberty, it should remain actionable, even without proof of special damage. Close quotation. That's enough for now. Toodaloo.